This video focuses on how the Supreme Court actually goes through the process of officially hearing a case. So there's three steps in this process. The first step is that each of the groups involved in a legal dispute, Roe v. Wade, Roe and Wade, Abington v. Shemp, right? So whenever two legal sides are battling against each other, each of their teams of lawyers file what's called a brief. These are kind of misnamed because when you hear brief, you think short, but these are massive written arguments, maybe 50, 60, even 70 pages of arguments about why the judges should rule in favor of their side and rule against the other side. One of the major things that the lawyer teams do in these briefs is they focus on what's called precedent. They try to look at how the Supreme Court has ruled on similar issues in the past, and they try to use those decisions to justify a victory in their case as well. So, like, hey, 10 years ago, you ruled in this particular case. It's not exactly like ours, but we feel like if you ruled in favor of person A in that case, you should be ruling in favor of our client as well. And in written form, you're trying to persuade the judges to rule in your favor and against the other side. This is a really time consuming process, and you would send these briefs into the Supreme Court months before your actual day in the Supreme Court. In addition to the actual two sides that are fighting in a Supreme Court case, the Supreme Court also opens up to outsiders to submit their opinions on how the Supreme Court should rule. These are called amicus curiae briefs. Amicus curiae in Latin roughly translates to friend of the court. So basically, the Supreme Court is looking for guidance to outside groups that are not directly involved in the dispute, but will be impacted by however the Supreme Court decides to rule. Right? These again are not directly involved in the dispute, but will be impacted by the Supreme Court's ruling in this particular case. So these are like groups again that are trying to persuade the Supreme Court to rule one way or the other in a particular case. If you look at like the case of Timms v. Indiana that we briefly talked about in class, there were 18 additional outside groups that each filed amicus curiae briefs. So now you have the two lawyer groups fighting against each other, submitting massive written arguments, but you also have all of these outside groups that have a rooting interest for some reason or the other to basically persuade the Supreme Court to take these things into consideration also. So this just like magnifies, multiplies the amount of reading that the Supreme Court justices have to do. And to be honest, this is where the clerks come in, right? The Supreme Court clerks will often, in many cases, read over a lot of this stuff and help the judges digest and summarize for them basically what these outside groups have taken into consideration. And then after all of this reading the Supreme Court has to do, you finally get your day in court. So each side involved in the dispute gets to make oral arguments in front of the judges. But remember, the judges have already seen your written arguments. Each side is limited to 30 minutes. That's it. So in Roe v. Wade, the famous like early 1970s Supreme Court case that dealt with abortion, each side only gets 30 minutes to make their decision. In the most recent decision, right, the Supreme Court made involving abortion, each side only gets 30 minutes. We deal with gun issues, the death penalty, only 30 minutes for each side. And at any point during your arguments, the justices can interrupt you and question you about things that you're either saying or that you wrote about in your briefs. And if they get hung up on a point that you're making and they spend 7 to 8 minutes asking you to clarify a point, you don't get that time back on the other side. Excuse me. So again, it's important to note that most of the argumentation is done in written form before you ever get your day in court, and then you only get 30 minutes to actually make your decision once you're before the justice, or 30 minutes to make your case verbally in front of the judges once you have your day in court.